Hello friends, how are you? Friends, concerning discharge under Prevention of Corruption Act, Hon'ble Bombay High Court has passed an important judgment in a case titled as Syed Mohammad Qasim versus State of Maharashtra. Judgment was pronounced on 13th of August 2024 and the judgment is pronounced at the cost of repetition by Bombay High Court. In that case, the accused has moved for discharge before the concerned trial court, but the petition was rejected. Usually we move before the concerned court for bail and our application might be rejected. In this case, the accused was caught red-handed and despite of that he was discharged. An important judgment concerning your rights. In that scenario, the concerned complainant is basically concerned with tour and travel business at MALAYALAM, Mumbai, and he used to do the same business with his friend. The complainant and his friend decided to purchase new vehicle, means taxi, in the name of company, and apart from that they require the special number. For this, they inter alia communicated with the concerned RTO. The concerned authority, named as Mr. Shailesh, inter alia told to the concerned complainant that the work is possible, but they have to pay the government fees and additional fees, which is termed as bribe by them in the report. Subsequent to this, they inter alia visited the office of ACB. The ACB verified the fact and ultimately pre-trap Panchnama has been prepared, and in the meanwhile FIR has been registered under section 7(8) of the Prevention of Corruption Act. The trap was organized and ultimately the accused was caught red-handed. One of the accused, named as Shailesh, was absconded from the spot, and in the meanwhile color test has been performed and Mr. Shailesh has moved for the pre-arrest bail, and inter alia the same was accepted by the court. Inter alia he moved for the discharge and questioning, the same was accepted by the court. The concerned accused number 2 also moved for the discharge, but the petition was rejected by the court that he was caught red-handed and there are sufficient evidence against him on the record, and that's why he could not be discharged from the alleged offences. So the question arises whether in such cases, when the ample evidence is on the record, what parameters are required to be considered by the defense counsels while arguing the case on behalf of their client before the concerned court concerned with the ACB cases. First, in this case, the concerned accused had submitted a detailed discharge petition. That is a very important point to be noted. In the application, he has specified that no offence has been made out because I have not been charged for section 7 of the PC Act. I have been charged for section 12 of the PC Act, which spells that I abetted the concerned public servant to accept or to commit the offence concerning with the anti-corruption. So in that scenario, the concerned public servant should be on the record, but when he is not on the record, I could not be prosecuted for the abatement of the offence which the court itself found not to be committed. In the present case, he relied on the judgment of Honorable Supreme Court titled as CBI versus VC Shukla. Friend, in this case, he submitted that the initial demand was not made by me, the demand always made by Mr. Shailesh. He submitted that the accused number 1, Mr. Shailesh, has been charged with section 7, 13(1)(d) of the Prevention of Corruption Act. Got the point now? And accused number 2 means the present applicant had been charged with section 12 of the PC Act. He submitted that the complainant requested for the special number allotment. But the key point is that the work has been done prior to the visit of the concerned complainant to the concerned ACB office, means the said part of the complaint is fictitious and false. And apart from that, there is no allegation of bribery demand by the concerned applicant, and even there is no allegation that he has accepted the bribe or promised to accept the bribe on the behalf of accused number 1. Subsequently, the trap has been done, but the money has been recovered. But in the meanwhile, certain attempts has been done by the concerned complainant to cause the trap of the concerned accused number 2, but the accused was not available, and in the meanwhile they got succeeded and ultimately he was apprehended on false basis. He submitted that even though he is caught red-handed, even though there is recovery of money, but the key point is that the acceptance is not voluntarily. He submitted that mere acceptance, mere recovery of the money cannot be a ground to assume that the concerned person is guilty. The prosecution is required to prove the demand. He submitted that the demand is not made by me. That is a very key point, and this point is uncontroverted. He submitted that the person who made the demand entirely discharged from the concerned court. He submitted that there is nothing, even the voice file, to show that the amount was demanded by me or amount was accepted by me on the behalf of concerned accused number 1, or even there was any reference regarding the doing of work of the consent complainant. Apart from that, there is no shadow witness to corroborate the said factum. When the prime allegations are not on the record, the prime accused has been discharged. There is no offence of section 7. In that scenario, I could not be prosecuted under section 12 of the Prevention of Corruption Act, and finally he got discharged. So this judgment inter alia provide us the following 10 remedies in case we got trapped in the Prevention of Corruption Act case. We have to rely on the same. Number 1, first of all, we have to see what are the allegations against us in the FIR, because allegations in the FIR are the prime context to bring into motion the criminal law that is called the Prevention of Corruption Act. Because in the said FIR, the consent complainant used to avert that the consent accused is going to demand the money. If the money is demanded, in that scenario, the consent Anti-Corruption Bureau of Vigilance or Lokaayukt assume that the consent accused is culprit, because usually they used to give the voice recorder, and inter alia, after having the voice recording, when the fact is communicated to the concerned ACB, they usually lodge the FIR without verifying the fact that whether the recording is genuine or not, without verifying that there is any cut shot or not, without verifying the fact that there is manipulation or not. Directly they proceed to lodge the FIR. That is a very wrong point on the part of concerned authorities. They have to verify the facts in the true context. If they are not verifying, in that scenario, they are doing the guilt of the violation of law, because you are having the right to get a fair investigation. So I am emphasizing on this point. Point number 2, observe what is your exact role in the statement of the concerned complainant and the other witnesses. That is also important, because the same is necessary to find out the corroboration, because usually these cases are not based on direct evidence. Usually they plant the evidences, but in fact they are not based on the concerned direct evidences. And apart from that, Honorable Jharkhand High Court in one of the cases specified that the testimony of the concerned complainant cannot be relied upon in toto, because he is an interested witness. So we have to find out whether there are any corroboration or not. If there is no corroboration, take out this point in your discharge. Number 3, find out from where the money has been recovered. If the money is not recovered from your person, in that scenario you are having a very good case to be discharged as per the observation of Honorable Supreme Court in case of Meera versus State of Maharashtra. Apart from that, we have to find out how many accused are there and whether you are robbed in as per section 34 of the IPC or as per section 120B of the IPC. If there is no allegation, there is no specification, there is no connecting evidence, then you could take the benefit. Number 5, if you are in the role of abettor, if the primary accused has been discharged, then you could have the benefit. Number 6, by whom demand is made, and apart from that, what is qualitative demand, whether it is going to be matched with the transcription. This criteria does not exist. In that scenario, you could have the benefit. Number 7, in the discharge petition, make out the specific case of fact, your defense, the law point, and what you want from the court, because usually they used to put up the consent recording, they used to put up the consent scenarios, but the key point is that whether there is a recording of you in the consent record or not. If there is no recording of you, in that case you could have the benefit. And apart from that, if there is mere acceptance without any urging on part of you that you are accepting the bribe on behalf of any accused, in that scenario you could have the benefit. So from the angle of benefits, you have to urge the same thing in your petition. Number 9, read the law regularly, and apart from that, if the consent story of the consent prosecution is false in context of the consent report, in that scenario you could have the benefit. And apart from that, the subsequent events, the falsification of story are the key factor and point to claim before the consent court while claiming the discharge. So corroboration theory, the motive theory, the pendency of work, the demand, acceptance are the prime factor. If they are uncontroverted, then you could easily claim the benefit of discharge. Okay now? So friends, no need to be worried, just fight about your rights and definitely we will win, sir. Okay ji? So do proper practice of your case. Number 2, read FIR, read charge sheet, note down the points and then argue efficiently, and definitely we will win. Okay ji? So friends, see you in the next video. Till then, Jai Hind, Jai Bharat.